strategic research, and also to capacity building of our members. But also, this is not only to our members, but also trade unions. And the purpose of having the ILO network, and I'm glad that we are having one of our funders here, is really to bridge the gap, because most of the time, workers, lawyers who are working in these spaces usually have, they're not as advantaged when it comes to having a platform where they can discuss strategies on how they can tackle the challenges in the world of work that is affecting workers. And that was really the reason on why this network was established. So just moving quickly, we are also going to hear maybe a little bit about Ellen. I don't know whether, Jamil, you have someone who can quickly speak about Ellen?
Hi, Jackie. I'm happy to talk about Ellen.
Perfect.
Good afternoon, everyone, and you're welcome to this webinar. Ellen is the Employment and Labor Lawyers Association of Nigeria, and it was formed in 2015. It's a collection of Nigerian qualified lawyers with interest in employment and labor law. Part of what we do is capacity building in the field of labor and employment law. And our webinar series is a key part of that strategy. We started the International Labor Standard Series in January in collaboration with our partners in ILO and the African Labor Law Society. Like Jackie said, to bridge the gap in knowledge about international labor standards, especially as it's assumed prominence in the Nigerian labor law jurisprudence. So this webinar series will run all the way to August. We've had 2 already. This is the 3rd one. And we hope that the objective will be achieved when practical stakeholders have better understanding of these principles. And we're very glad that we have the cream of experts today on this panel. So this is wishing you a nice participation, and thanks, Jackie, for moderating this. Thank you.
Thank you so much, Jamil. I'm not even sure whether you introduced yourself, your name.
Yeah. Yes. So I get carried away introducing Ella that I forget myself. My name is Jamil Akolade. I am the founder and one of the trustees of ELAN. I'm also a management committee member of the African Labor Law Society. And of course, we've done quite some bit of work with ILO too. So thanks.
Thank you so much, Jamil, for the introduction. So we are going to get into the issues for today around freedom of association and collective bargaining. And our first panelist is Jeff, who is the Rule of Law Director of the Solidarity Center, and also he's the co-founder of the International Lawyers Assisting Workers Network. And in 2022, he was appointed to the ILO, the International Labour Organization governing body, as the US worker representative, but also he serves at the ILO Committee on Freedom of Association. He's been working, he has worked with the ITUC, that is the International Trade Union Confederation, as the legal director, but also before he joined the ITUC, he served as the deputy director of the FLCIO at the International Department, and previously at its Global Economic Policy Specialist. He's a graduate of Cornell Law School, where he earned his JD and also LLM International and Comparative Law. But also he studied at the International Law at the University of Paris. So in his discussion today, he's going to cover different areas in terms of Convention 87 on freedom of association and Convention 98 of the ILO, looking at really some of the challenges that we are facing in the new world of work, because of course, as we know, especially from this part of the globe, we have a very high informal economy, but also the gig economy is growing. But what does that mean when it comes to the to freedom of association and collective bargaining? But also he's going going to talk about different issues around compliance, but also his experience at the Committee on Freedom of Association, but also he's going to touch a bit on how we can utilize some of the ILO supervisory mechanism. But also he's going to talk around the issues to right to freedom of association, but looking at the recent development around the right to strike. And he cannot, he's the best person to talk about these issues because he's written vastly about the issues on the right to strike. But before that, I want us to do a poll. I don't know, Jamil, can you launch the poll around where we
It's
have?
already.
Oh, it's already been launched. So I don't know whether everyone can see the poll. So if you go to the poll button, just at the bottom of the Zoom app, you'll see, okay. Okay, this is perfect. So I can see that you've already participated on the poll, and I'm not going to end it. So if you haven't participated in the poll, please do. The first question is on, do you think workers in the informal and digital economy have the right to organize? So it's a yes or no. The other question is, do you think that the right to strike should be an absolute right? So far we can see that the first question, everyone said that indeed, yes, actually 100% say that indeed workers in the informal and digital economy have the right to organize. But on the second question around, do you think that the right to strike should be an absolute right? We have 50% saying yes and 50% saying no. So this is quite a contentious question, and I hope that, Jeff, in your presentation, you'll be in a position to answer this. So I'm going to leave the poll open as we hear from Jeff. So if anyone has not been in a position to look at the poll, please do that. So I'm going to pass it to you, Jeff. Karibu sana, thank you.
Well, thank you, Jackie. And you've given me a very long list of things to discuss in like 25 minutes. So I'll do my very best to cover as much of that as possible in that time. But I think probably the most important is leaving plenty of time for discussion and questions so that I can really respond to the questions that you have rather than just giving a lecture. But I'm going to now try to go through that very long list. So, it'd be interesting to know first how many of you have any experience with the International Labor Organization, or at least aware of it. I don't know if you can raise your virtual hands or not, but it would be useful to know. If not, I'll give a very brief background. International Labor Organization was formed in 1919, following the First World War, recognizing that and it says right in the original Constitution that there could be no lasting peace without social justice, right? And there was and still remains vast amounts of labor exploitation, which the founders of the ILO sought to address by a mechanism that brought governments, labor, and employers together to try to seek common ground to regulate the global economy, right? Though this was seen at the time very much setting rules for how national governments, together with unions and employers, would be regulating work at the national level. So I think the thing that is unique about the ILO is, in fact, that when the UN was established in in the 40s, the ILO joined the UN family. It is unique in that it is not just governments that attend the ILO. It is governments have 50% of the voting power within the ILO, but workers have 25% and employers have 25%. So in order for anything to really happen, you typically would need support of all three groups, though I will mention some interesting exceptions to that took place recently. And so workers have a role in actually negotiating international labor standards through conventions and recommendations. They have a role in supervising those standards. And as Jackie mentioned, I'm a member of the Committee on Freedom of Association, which is a committee that is established to review violations of freedom of association and collective bargaining. And so that, I mean, I think it makes it a very interesting organization in that regard, in that workers do have a voice and can influence the direction of labor law as an international principle, and then making sure that these rights that are established at the international level then come down to the national level in practice. So when we talk about freedom of association, there are several instruments that I think we need to take into consideration. The first is the ILO Constitution. Again, the original Constitution from 1919 does recognize that among the pressing issues that need to be addressed by this new organization at the time was the right to freedom of association, right? So it was seen then over 100 years ago that this is important, because at least in the countries that were important to the foundation of the ILO at the time, and I'll speak to the kind of US experience, and some in Europe, you had unions that had been deemed to be these kind of illegal combinations, right? That the idea that workers in the late 19th century, whether in the UK, US, or elsewhere, when they formed collectively to withdraw their labor or take other forms of action against employers with regard to the exploitation, they were seen as engaging in illegal activity. And it was only the late 19th, early 20th centuries that we saw legislation that excluded them from competition laws, and eventually in the US in the 30s, but in other countries at other times, specifically regulating the right for workers to form trade unions, to bargain collectively, and to strike. So the Constitution is important. Conventions, there are several, but I'll focus in on two. There's Convention 87, which was adopted in 1949 on the right to freedom of association and to organize. And then the following year, the right to organize and bargain collectively. And these two are kind of the key pillars of these rights. And in 1998, the ILO identified 8 conventions that were deemed fundamental out of the 100 and some at the time of 1998. And Convention 87 and 98 on freedom of association and collective bargaining were deemed to be fundamental conventions, along with conventions on forced labor, child labor, non-discrimination, and just last year adding occupational safety and health conventions to that list of fundamental conventions. So conventions being deemed fundamental through this declaration, this declaration basically stated that even if you have not ratified these conventions, right, there's an expectation that just by merely being a member of the ILO, that you are expected to respect, promote, and realize the principles of these conventions in law and in practice. So there's really no excuse, ratification or not, to not give effect to these principles. So so the Constitution, those two conventions, and the 1998 Declaration, which again was recently amended, I think are the really key ones to focus in on when we talk about freedom of association, the right to collectively bargain. So what do these conventions mean in practice, right? And I think starting with freedom of association, and this goes to the poll that you saw at the beginning as you logged on, is that the right to freedom of association is a right that every worker has, right? It does not depend on whether you are in an employment relationship. The only exception in the convention is police and members of the armed forces in combat services, right? So countries can extend the right to freedom of association to them, but those are the two that can be kind of lawfully excluded from the right to freedom of association. All other workers, right, had the right to freedom of association, and that includes workers in the informal economy, right? And I will put in the chat here a publication that we just published with WeGo earlier this week. And that is a guide on how workers in the informal economy can apply Convention 87 to the specific set of issues that relate to them, right? So, many labor laws around the world still, have say the scope of our labor law applies to employers and employees that are, have a contract of employment, right? So that is covering formal employment, but in many countries that is leaving out the majority of workers from the protection of the labor law. And that's obviously needs to change. Or workers may be able to form some sort of association, but it may not be an association that is able then to collectively bargain or have the same or to strike or to collect dues or these sorts of things. So there can be a number of limitations on all alternative structures that could be created. So the Convention 87 recognizes the right of workers to all workers to form unions of their choosing, right? So there has to be freedom to either join an existing union, create your own new union, right? And that there shouldn't be obstacles that are created by governments to the registration of those unions. And again, this is where governments can put in very high membership levels, minimum membership levels, or very complicated registration procedures, or ask for all kinds of documents which really aren't necessary. And these create obstacles to registering organizations. So unions under the convention should be able to set up their own rules, their internal governance, set up whatever committees they want. They should have the right to figure out how they collect dues, how they fund their activities, and to determine what those activities are, right? And one of the important things is when we talk about the rights of unions to undertake their activities, is that those activities include collective bargaining and otherwise representing members in whether it's in the collective bargaining process or in grievances or before tribunals or in any number of ways that workers can be represented. And that also means the right to strike, because if you don't have the right to strike, collective bargaining is essentially a meaningless activity because you have no leverage at the bargaining table. Convention 98, and I'm again being very brief because I know we're running short on time. Convention 98, recognizes the right of worker organizations, trade unions, to enter into collective bargaining with employers and employer organizations. it's based on the idea of voluntary collective bargaining, but this means that while no party may be obligated to sign a collective agreement, that it is not voluntary to engage in a collective bargaining process, right? The idea is that if a worker presents or a union presents demands to an employer where the union is recognized, that there should be good faith collective negotiation with the union with the aim and the objective of trying to reach an agreement, right? And this is another area, in addition with the right to strike, that the employers are very much pushing back on. Obviously, another kind of key component of Convention 98 is the right to be free from anti-union discrimination. And obviously, we know that when workers are seeking to form a union or engaging in union activities, they can be disciplined. They can lose benefits. They can be transferred to another department. They could be any number of things could happen, or they could be fired. Right? This is very typical that union organizers, union leaders, union activists can be fired for their completely legitimate activity. And the Convention 98 makes it clear that this is illegal, right? If you don't have protection from anti-union discrimination, there's not much you can do as a trade union, and in particular, if you don't also have a right to strike to collectively push back on decisions made by the employer. So I've kind of given you a little bit about the structure of the ILO, the key instruments that protect the right to freedom of association, collective bargaining, and some of the key elements of these conventions. So how do you use them, right? So the ILO has a number of ways in which trade unions can contest violations of these rights in these instruments. Every year, or well, every country that has ratified these conventions has an obligation every 3 years to report on their compliance with these conventions. Workers and employers also have the opportunity to file their own observations to the ILO, so it keeps it allows for a more honest and accurate picture to be presented to the Committee of Experts. And then the Committee of Experts will publish a report which includes kind of their analysis based on these reports from the government, employers, and workers as to whether the country is in fact, the government in fact respecting the right to freedom of association to bargain collectively. If that report, so say we're talking about Nigeria, they've ratified these conventions. If the report in a particular year, identifies that there are violations of this right, then during the International Labor Conference, which happens every June, right, there's a standing committee called the Committee on the Application of Standards. They can pick a number of cases from the report of the Committee of Experts to prioritize and discuss. And a number of cases usually that are discussed by the Committee on Application of Standards are violations of freedom of association and collective bargaining. So this is another opportunity for there to be kind of oversight on country practice on freedom of association and collective bargaining. And the Committee on Application of Standards can provide recommendations to the government and the ILO as to how to improve the situation in the country. And then one of the final ways I'll talk about, and this refers to the committee that I'm on, at any time, a worker organization can file a complaint to the Committee on Freedom of Association alleging a violation of the right to freedom of association in law or in practice. And Importantly, this is doesn't matter if the country has ratified Convention in 87 or 98, because the one of the bases for the jurisdiction of the Committee on Freedom of Association is the Constitution itself. And as I mentioned at the beginning, the Constitution also protects freedom of association. So the committee can hear, again, violations regardless of ratification. And then we can, as a committee, receive a complaint filed by, almost always by, a union. That complaint is sent to the government. We get the government's response, and then we look at the information provided by the workers, by the government. If a specific employer is mentioned, the government can also forward the responses of the employer that's been identified, and then we will, based on the facts before us, assess whether there's been a violation of freedom of association or collective bargaining, and issue a report with, again, conclusions and recommendations on how the government, if they have violated those principles, can comply with them in practice. And we meet 3 times a year and cover roughly 15 to 20 cases each sitting. And I think this last one, we dealt with Algeria, I think of other countries in Africa, Cameroon. I'll have to go back and look. But so that is the overall process. And I know I'm going very quickly because of time, but again, I'd be very happy to take any questions that you have. And then to the last thing that Jackie asked me to touch upon is the dispute on the right to strike, which itself can take the next hour and a half, but I'll spend 2 minutes on it, basically to say, as I mentioned before, the right to strike has been interpreted to be protected by Convention 87 almost since its inception in 1949. The second time that the Committee on Freedom of Association met, they affirmed that the right to strike is an essential corollary of the right to freedom of association. But it was in 2012 that the employers made the argument, despite over 60 years of continuous jurisprudence on this point, argued that the right to strike is not protected at all, right? And that created a bit of a crisis within the organization. And it was only last November that the governing body, the workers and governments, without any support from the employers, decided to refer the dispute to the International Court of Justice for an advisory opinion. Briefs are due in a couple of months in May, and then again, reply briefs in September, with oral arguments likely at the beginning of 2025 and a decision later in 2025. So I think we'll leave it there. I hope I haven't exceeded my time. Very interested to hear from my co-panelists, and happy to take any questions at the end. Thank you.
Thank you so much, Jeff. I think one of the main takeaways is that every worker actually has the right to freedom of association according to the ILO Convention 87, and it doesn't matter if they are in an employment relation. So workers in the informal economy, workers in the digital economy, and so on and so on. But also on other issues on how to utilize the ILO supervisory mechanism in ensuring that governments are actually respecting the right to freedom of association, but also collective bargaining. So our next speaker, Adewale Smart, is currently the Director General of the Nigeria Employers Consultative Association, NECA, with over 18 years of experience in human resources and industrial relations, organizational development, business sustainability, and evidence-based advocacy. He leads the strategic growth and development of over 4,000 employers and 35 sectoral employers federation across all sectors of the economy. He is also a member of the governing body of the International Labour Organization. But also he's an ILO trained master trainer on different issues. He's also passionate about promoting decent work, social justice, but also inclusive development for all. And he's, of course, attended different courses at both local and international institutions. He's a full member of the Chartered Institute of Personnel Management, but also a fellow of the Michael Imoudu National Institute for Labor Studies. He's currently pursuing his PhD in industrial relations and personal management at the University of Lagos, where he actually obtained his master's and bachelor's degrees. He's also an author, but also a public speaker and youth advocate, but also a teacher. So welcome, Mr. Adelawe. He's going to take us through different issues, especially from his experience on industrial relations, but also mentioning maybe about the successful strategies around freedom of association, but also in terms of how it's useful in industrial relations, and also maybe talk a bit about the gig economy when it comes to issues to do with collective rights. So karibu sana, Adewale Smart. You're next and you have around 20 minutes max. Thank you.
Thank you very much. I'm not pronouncing your name but wrongly. And thank you, colleagues. Good afternoon, everybody. And it's a pleasure to be part of this conversation. And also let me say thank you to Jeffrey for setting the tone for the conversation. I think he has shared the foundation of the ILO, what the ILO does, the fundamental conventions, the core conventions as we call them, and then the other frameworks that makes the ILO what it is, probably the most important UN agency from our perspective, and the most unique also because of its tripartite nature. Having said that, let me start from the last comment that the last issue that he addressed concerning the issue of the right to strike. I think, as he said rightly, it was a very contentious issue. It remains contentious until it was referred to the ICJ. Rightly also, it's correct to say that it received absolutely no support from the employers group. The workers pushed it, and a substantial number of government also pushed it. Not all government, as mentioned. At least I know that the Nigerian government did not support it, and some other governments also did not support the issue going to the ICJ. Fundamentally, we believe that ILO being a social dialogue house, the DNA of the ILO is social dialogue, and whatever happens, we must exhaust all avenues for social dialogue. That is the position of the employers, and that's the position that we still hold. Let's go to the ICJ and we just see what comes back from the ICJ, and then we move on from that. Having said that, I also have a bit of a list here that I will try and touch within the time allocated, and basically for me to look at the how do we anticipate the evolving nature of work impacting labor relations between employers and workers, particularly in sectors heavily influenced by digital transformation. One of the first things I like to say is progressively we have seen that innovation across sectors, especially from the digital space, is happening faster than sometimes than we anticipates as government, sometimes anticipates as social partners. And the digital space, as we find it now, or even the world of work itself, as is evolving faster than our government's ability to create frameworks or to create structures to manage or to manage the digital space. And the digital space, as we find it now, or even the world of work itself, as is evolving faster than our government's ability to create frameworks or to create structures to manage, to create structures to manage the digital space. To create all those issues as it were. So for us, it's speaking also directly from our experience from Nigeria and then from the African context. We realize the rate at which the workplace is changing. Even our labor laws, our legal frameworks, is not positioned as it were currently to address all of those changes as we have seen them, either changes arising from digital platforms, either changes arising from the high technological influence on the financial sector even now, also from the challenges that we've currently faced and persistently that we have faced in formalizing the informal sector. So the jurisprudence in our part of the world, in Nigeria as it were, and most African countries, is not catching up with the issue of how do we regulate, how do we manage, or how do we make that environment um, much more hospitable for operators within that context to operate within the context of their rights, within the context of their responsibilities, maximizing the opportunity that exists within the ecosystem, and also maintaining a peaceful industrial relation system. So for us, it's still a bit of a challenge for us, basically. It's a bit of a challenge for us within the context of Nigeria. And globally, while Europe, America probably have done quite a bit in creating structures to help the informal sectors to be organized within the context of their own opportunities, within the context of their ecosystem. But that structure, we currently don't have it in our side, which unfortunately exposed operators in the informal sector and also confer some level of advantage, depending on how you want to look at it, confer some level of advantage on those operating in the digital platforms. I know at the ILO level and also at the IOE level, we know there are a lot of conversation currently going on the issue of the platform economy. Platform workers, are they really platform workers or are they platform employers? Because we have people also employ people operating within the context of that platform that they are not working for somebody. They are basically the owners of their platform. They are basically the owners of their enterprise. So how do we demarcate them? Do we call those workers, or do we call those operating in that context employers? So the framework to guide the delineation of those actually operating in the platform economy. I know it's a conversation that is currently going on at the highest level of the International Organization of Employers. From my experience, what are some successful strategies employer can implement to ensure fair treatment and representation for workers in the informal sector? One of the things we preach from our hand, from the perspective of Nigeria Employers Consultative Association, is first of all responsible enterprises. Responsible enterprises within the context of respecting the rights of workers, both in formal and informal space. We absolutely respect and also affirm the core conventions of the ILO, Convention 87. We affirm it. We are protecting it effectively, even within the context of our relationship in Nigeria, because it doesn't only apply to the workers. It is the same convention that guarantees the workers' rights that also guarantees the existence of the employers, because it explicitly states the right of workers, the right of it guarantees the existence of workers' union, workers' representative, and at the same time it guarantees the existence of the employers group, which we belong to. So to that extent, we affirm, we protect, and we also guide jealously the provisions of that convention. The challenge still remains the issue of the informality. Now, without missing words, I would say we have a peculiar challenge, a peculiar challenge from our experience. Sometimes you worry if those in the informal sector actually want to be formalized. Because to a large extent, from our experience, lot of the things that happen in the informal sector to a large extent is out of the core focus of regulators, is out of the core focus of legislation, is also out of the core focus of those that are supposed to carry out inspection, those are supposed to enforce certain laws, certain guidelines within the national context. So for an average informal sector operator, operating away from the global view sometimes is a plus for them. So we realize consistently that even while we make deliberate efforts to help those in the informal sector to formalize, because on the long run, for employers groups like ours, the more of the informality you are able to convert to formality, and the more those businesses grow, the more potential members that you have as an employers federation. So the more you get them from informality to formality, the more they grow, the more they thrive, the more they expand. Those become absolutely your potential members. But because of the reality of the environment in which most of those businesses in the informal sector operates, within the context of our experience, then sometimes it becomes a hard call for them to follow your guide from informality to formality. Some find it, some misinterpret being formal to increase responsibility to regulators, increase responsibility to the tax authorities, increase responsibilities to the inconsistencies, even policies that government sometimes churn out. So it creates that difficult dynamics for us to actually get those in the informal sector to be absolutely, all of them, to move from that informal state to the formal state. Now, the gig economic growth. My thought on mechanism to ensure adequate labor protection and collective bargaining rights for the platform workers. I think the first thing for us will be this, is to create structures. A structure that not only identifies, or a structure or a framework that delineates who exactly is operating in that gig economy. Are they employers, as I mentioned? Are they workers, or how exactly do we delineate them? Once we create that structure, then it will be easy. It will be easy for them to operate within the context of existing structures. But currently, if we don't have that structure, if the informal are not formalized, then it becomes even difficult within the context of getting them to organize and getting them to collectively bargain. So as we have advocated in our economy, as we have advocated in Nigeria, like, the first thing is, let's create a structure to appropriately identify those that are operating in the gig economy, appropriately identify those that are operating in platform economy, and then let them fall within the existing structures of the ILO, whether the structure of Convention 87, whether the structure of whether other existing structures that we currently have. It becomes easy to relate with them, and it becomes easy for them to be protected within the context of the existing structure. You know, few things happened about 2 years ago in Nigeria. I think some things happened that were quite troubling. You know, the government actually placed a blanket ban on majority of those operating in the platform economy. They placed a blanket ban on many of those businesses because the government felt that they are out of its regulation. That it was difficult to regulate those businesses operating in the platform economy. And they create this blanket ban. The government tried to frustrate their existence until the government created a quasi structure that, instead of promote those businesses, you know, it stifles those businesses, but it makes the government objective of getting them to work within the structure that the government has, even when those structures are not alive to the needs of those businesses. So it comes back to the issue I raised earlier that look, the rate at which technology, the rate at which innovation is growing, it's a bit difficult for our government to catch up within the context of regulation, to catch up within the context of providing frameworks that will allow all those businesses to work and work effectively. And without a framework, without a structure, in whatever context, whether a formal structure, whether an informal structure that is generally acceptable to all practitioners, then sometimes might create problem within the context of collective bargaining or even exercising certain rights, especially when the jurisprudence, even when the jurisprudence of the country does not take cognizance of all those issues that will arise within the context of the platform economy. While the Nigerian jurisprudence, the Nigerian courts have progressively been applying the ILO conventions, bringing in best practices from the ILO convention to adjudicate issues concerning labor and employment, you also find out that many of the lawyers, maybe not in this platform, many of the lawyers are also not very vast within the context of understanding the provisions of those conventions. They are not very fast within the context of understanding the provisions or how to apply or how to plead, as the lawyers will say, some of those reliefs that the conventions, even when we don't ratify them, that those conventions might give. So it creates a bit of challenge, sometimes confusion within the context of the jurisprudence in our own economy. But all it boils down to having a framework. I've mentioned framework close up to 10 times now, a framework or a structure that can delineate and allow everybody within that ecosystem, both employers, both workers, and then the court itself, allow them to work and then adjudicate issues that might arise within those issues. In my experience, what are the main concerns or obstacles that employers encounter when dealing with workers' exercise of rights or freedom of association? Well, sometimes, there is always a thin line. There's always a thin line, and it depends on the ideology. The ideology, the temperament, the knowledge, and the disposition of whoever is leading whichever organization. Employers sometimes have issues, have concerns within the context of the issue of freedom to associate when workers misinterpret even the structure in which they work. Let me give you a practical instance. We have, and these are issues that have happened in the past. We have a business that is predominantly in the maritime industry. We have a business predominantly in the maritime industry. And in the business group, the group of companies, you have some individuals working in the predominant business, which is maritime. You have some individuals, some other workers working in another sub of that company in catering and hotel services. You have another business working, they also have an outlet that sells premium motor spirits. Now, the expectation is that within the context of the right to organize, that those working in the maritime business will belong to the maritime union. That those working in the hotel business will belong to the food and beverages union, the way we call them here. And those working in the oil and gas sector of the business will belong to the oil and gas union. But sometimes, because in our environment, the oil and gas is more lucrative. The terms and conditions of employment in oil and gas is better than most other sectors. And then we've had issues where those working in the maritime sector prefer or inform management that they rather belong to the oil and gas sector unions, or those in the hotel and personal services union say they would rather prefer to belong to the union in the oil and gas. That creates a lot of friction because look, your core work, your core responsibilities, your employment is domiciled in the maritime sector. Your employment is domiciled in the food and beverages sector, not in the oil and gas sector. So it becomes difficult convincing some of our colleagues sometimes to say, look, you don't belong here. You belong in this other sector. And those are predominantly the kind of issues we've had to deal with over time. But for us, with consistent education, with consistent engagement, I think those issues are basically going away. And employers in Nigeria, basically, apart from some that you will find, as you find them everywhere, they have a negative perception, probably because of their past experience with unions, probably because of their ignorance or their lack of understanding of the role that the unions should play in their businesses. They resist the formation of unions, or they try to stifle the growth of union in their environment. But as many of them as we know, and as many as we engage, progressively, you also realize that many employers are also opening up and allowing the formation of unions in the organization, and also the promotion of a peaceful industrial environment in their businesses. To give
Mr.
an example
Adem,
of successful.
you have 2 minutes to go.
All right.
Thanks.
Could you provide example of successful collaboration or strategies employed by employer to foster construct relations with trade unions? And for us, I think we have many success stories, basically. During COVID-19, those are very, very important, very difficult times for employers in Nigeria and workers. We actually signed an MOU with organized labor then that no employers will retrench. No employers will retrench any staff, except it is absolutely necessary. And most employers will kept faith with that MOU to say, look, no employers will retrench any staff during COVID. That was one of the many success stories of collaboration that we have with organized union. And also within the context of decent work, we also have a very strong partnership with our partners, the organized people, and also the ministry. As many employers that are not living up to the context and the spirit of decent work, we will continue to expose them, we'll continue to shame them, and we'll continue to expose them to the Ministry of Labor for proper action. And lastly, just for the 30 seconds remaining, my thoughts on the future of labor management relations, particularly in context of evolving work arrangements and technological advancement. I think for labor and employers, if we are not careful, technology will create, rather than becoming advantage for us, rather than becoming positive for us, they may actually create problems for us. Because with technological advancement, if we don't brace up to redefine our value propositions, union to its members, and employers groups to employers, we realize progressively we'll be losing our members, and progressively the strength that we tout, the numbers that we tout as our strength, might eventually become a weakness for all of us. So it's for us, both employers groups and workers union, to continuously redefine our value proposition to our current members, and then for those that are potential members, so that we don't lose our relevance suddenly. Yeah. Thank you.
Thank you so much, Mr. Adewale. I've also seen that you've raised quite contentious issues in your discussion. One of them being to do with the issues in the digital economy, where you find at times in a platform, you can actually be a subscriber on the platform, but also you are employing someone else to use the same platform. So would you be considered, would you exercise both your right to freedom of association from a worker's perspective, but also from an employee perspective? The other thing that I found contentious is on the issue of formalization of the informal economy, that some workers in the informal economy would not necessarily want to be formalized because of the burden that comes with formalization. However, I think also this has to be looked from a perspective of rights, whether like workers in the informal economy want to access rights and protections that comes with the formalization processes as highlighted or prescribed under the recommendation 204 on formalizing the informal economy. However, I can see that we have like different questions on our chat, but also I can see that Jeff has been in a position to answer some. I can see one that is directed to Mr. Adewale on whether you need to clarify what is the status of NECA as to whether it's an employer trade union or not. So I'm going to push that to you because at this particular point, I would like you to answer that and also to open it up for discussions in terms of what have been the experiences in terms of accessing the right to freedom of association and collective bargaining. Because I can see that we have workers' rights lawyers here, but also I can see comrades from Tukoswa all the way from Eswatini. I can see different practitioners in the space. So they would be in a position to really maybe share their experiences on what really goes on the ground, despite maybe the constitution providing from the freedom of association and collective bargaining, but also the countries ratifying Convention 87 and 98. So I'll pass it over to you, Adewale, and as we see whether there are other questions.
Okay, the first one, whether clarify status of NECA, so whether it's an employer's trade union or not. NECA is not an employer's trade union. It's an employer's federation. It's an employer's federation which has metamorphosed into a employers business, called a business membership association now, or business membership organization. So we are not viewed in context and in concept in line with trade unions. We are employers representatives, but not employers trade union.
Thank you very much. There's also another question on, and this one I'm going to open it up to everyone in this webinar, as the Asia-Africa liberal economy characterized by the takeover of the African retail sector by Asian oppressors and gross violations of Convention 87, and I think you meant 98, are very concerning in countries like Eswatini. How is this problem arrested in other African countries? So maybe we can have someone respond to this or even ask further questions. I'm just checking on the chat whether there's anyone.
Let me say something on this. Well, first,
Okay.
I've tried to check the let me thank Jeffrey for the link that he shared. I think I've opened the link and I think I find the content quite incisive, just perusing. But on the issue that on the issue of the Eastern African liberal economy, I think it's a concern, it's a concern everywhere. And I am a big advocate. I'm a big advocate of not only regulation, but effective implementation of regulations. We have stories, same also in Nigeria, where some people perceive or feel that yes, the incursion of Asians, I don't want to call them Asian oppressors, because before somebody can oppress you, really, there will always be local collaborators. So if you have local collaborators, then you can't rightly call those that are, you can't really call it an oppression as it were. So for me, I think it all boils down to regulation, and that's what we have canvassed here. You have instances where their attempt, strong attempt to undermine the system. And our view and what we have canvassed consistently is to put the Ministry of Labor on the spot. If the Ministry of Labor has the right to carry out inspection, if the Ministry of Interior have the right to regulate the activities of people we call expatriates, if the Ministry of International Affairs have the role to play within the context of their operation, if the Ministry of Industry, Trade and Investment have a role to play within the context of their operation. So what we have done basically is to put those that are responsible within the context of regulating the operations of every business in Nigeria, is to put them on the spot and insist that regulators must regulate, inspectors must inspect, so that at every point in time, you have organizations and businesses that are doing the right thing at the right time. And from our part, I mentioned the issue of responsible enterprises. We also take conscious efforts to be silent whistleblowers. Once we get an organization, whether it's an Asian organization, whether it's an American organization, whether it's an African business, African-owned business that came to Nigeria, once we realize they are not doing the right thing, one of our responsibilities is to escalate to the ministry, escalate to those authorities, and ensure that those authorities, they do their statutory role or carry out their statutory function of inspecting, of regulating, and slamming sanctions when it arises. So for me, it's not boils down to regulation, getting the regulators, getting the government officials to carry out the function for which they are created. Other issues surrounding it, I want to go into it, issues of corruption and such like. But for me, until we all take those personal responsibility, either as a lawyer, either as employers, and also as workers, until we take those personal responsibilities to expose those that we termed oppressors and bring them to the fore, then we'll continue to complain about the incursion of those that we call us oppressors into our continent. But for me, there's no oppressor without co-conspirator. And if we make ourselves co-conspirators, then we are also as liable as them.
Thank you so much, Mr. Adewale. So let me just quickly read what Derek had asked in the chat, which is, I would like to believe that when we are talking of the right to strike, we are referring to protected strike action in terms of ILO conventions. Can these rights be limited by common law in the absence of legislation of general application, in particular the law of interdicts? So, and Jeff has responded in the chat that the ILO establishes principles on the right to strike. If the limitations on the right to strike at the national level exceed the limitations established by the ILO, then it would violate the convention, regardless whether statutory or common law. So I've also seen Robina's comment. If workers have a right to organize and collective bargaining, why should the enjoyment of these rights, especially the right to collective bargaining, be first conditioned to recognition by employers? So that's first question to Robina, by Robina. So maybe either Jeff, you can respond to this. This question is to Adewale on what is the position of NECA on of trade unions in view of the National Industrial Court's recent decision that formation of trade unions should be unfettered. So Jeff, and then Adewale.
Yeah, good question. So like the way the ILO the way this is set up on collective bargaining, like any group of workers who have formed a trade union can obviously attempt to get an employer to negotiate and bargain collectively with them, right? It is many labor law systems will say that once a union meets a certain threshold, 20% of the workers in an enterprise or a sector or whatever, or 30% or some number, or a majority if it is going to have effect over all the workers in an enterprise, there'll be some threshold that'll have to be met. And once that threshold is met, then the union is there's an obligation then to negotiate, and that collective agreement may have effect not only over the specific members of the union, but may have cover the totality of the workers at the level of the negotiation, whether that's the enterprise, workplace, enterprise, sector, occupation, national collective agreements. So that's it. It's not so much the employer recognition as much as it is the size and strength of the union itself, and whether the national legislation creates certain thresholds for collective agreements to apply for all workers, including non-members, right? And that's usually in a situation where you have a majority representation. So I hope that answers your question, but if not, then happy to further clarify.
Thank you so much, Jeff. Robin, I hope that answers, but if you have further question, you can just either raise your hand or you can post it on the chat. Mr. Adewale, on the issues of multiplicity of trade unions.
Well, we fundamentally, we have no issues with the formation of trade unions, but we have concerns with the proliferation of trade unions. Our belief is that trade unions should be formed along industrial lines, which is what the law says. If they are not formed within the context of industrial lines, and we use the word literally as it is, proliferation of trade unions, that everybody can wake up and say, okay, they have formed their trade unions, then it makes operation even of the business quite cumbersome, because you might find yourself in a situation where you have to deal with multiple unions playing duplicated roles and playing duplicated functions, which might be problematic for us. So we support the formation of trade unions, but those trade unions must operate within the context of industrial lines, as we currently have it, notwithstanding the decision of the NIC.
Thank you, Mr. Adewale. David says that the issue of Asian oppressors can only be handled if the government of each African country creates an enabling environment for accessing gainful employment. So the absence of this to the knowledge of even the government will make it difficult to regulate certain unhealthy employment practices. Of course, implementation of laws and regulations by the authorities is necessary, but also most of the laws are obsolete. So there is the need to overhaul the legal framework and also strengthen encouragement. So Robina also says that, Jeff, you've answered the question. So at this particular moment, and please, if anyone has a question, please do not hesitate to raise your hand or post it in the comment. And also David asks Mr. Adewale, what are your thoughts on the consistent and persistent refusal of employers of casual workers to unionize, especially in Nigeria? And Robina says that currently in Uganda, the threshold rule was removed both for formation and trade union recognition, which I think it's a good step. But before Mr. Adewale, you answer that question, I want to call up Mr. Sticks. I can see him that he's here from the Transport Workers Union in Eswatini. If you can just briefly, maybe in 3 minutes, just share your experiences in terms of challenges of accessing freedom of association, particularly the issues of the right to strike around maybe even the informal economy. Please, if you can do that, we'd really be grateful for your contribution. I don't know whether Sticks, you can unmute and speak to this.
Yeah, thank you very much, Comrade Jackie. Greetings to your participants. Well, Swaziland, it is a very difficult space to for workers to practically enjoy such rights. Even in instances where sufficient majority has been established by a particular trade union organization. And we've seen a deliberate and a consistent effort on the part of the government by flooding the labor space with a free and easy way of registering trade unions, and some of them the government-sponsored and employer-sponsored, which then weakens the leverage for labor to put across their demands and push for betterment of the workplace environment in Swaziland. And then another calculated effort that the government is doing is to unleash its security forces, even on instances where there's been a complete compliance to the prevailing legislation. And on instances where the courts have even said the actions are legalized, they can go ahead. At one instance, we had the head of police who had to tell a gathering of workers to say, I am the court order. I hear that you're saying there's a court order allowing the process, but I am the court order now saying the action will not continue. So they are the obstruction to such enjoyment of these rights comes from the government, comes from the employers, and these impediments have been making practical enjoyment of these rights to be very limited. We wish to appreciate the collaboration that we've been getting from comrades across Africa and beyond, and to the govs that were really pushing such matters to the ILO, and some of them have been decided very progressively to take the country. Because what we've seen is that the government takes particular attention and respect to the decisions of the ILO. Thank you, Comrade Jackie, and your participants. That's my bite. Thank you.
Thank you very much, Comrade Sticks, for sharing your experiences from all the way from Eswatini. I can see that we have some more questions in the chat. Maybe I read them and I'll ask both Jeff and Adewale to address this. So currently in Uganda, okay, I had read that one. Derek says that refusing workers the right to organize should be made a strict liability offense. Maybe we should have done a poll on that question. So that comment, I mean. So Phyllis, hi, I thank ILO for this awesome webinar. Karibu sana. Kindly, would you share your take on sibling rivalry among unions and the ugly effects? Can we hear case studies from respective countries represented here? I've seen that Ellen has responded to the saying that it's actually a real issue in Nigeria, and we have lots of court cases related to the struggle for dominance by trade unions. What the law has tried to do is to define the scope of each union, but the issues remain the same. And Jeff, maybe I would like you to speak more on this. I know that there's been some I will not call them rulings, but the CAS has also like looked at this issue around freedom of association and looking at whether government has the right to even regulate the scope under which a union can be formed where there is already an existing union. So Furaha, thank you so much for hosting this discussion. Has the right to strike when emergency powers are employed ever been tested successfully? And Phyllis Mwendwa also continues to ask, how is the sibling rivalry among trade unions handled by umbrella unions? This is Kamuye. I think this question is directed to Kamuye. I think Kamuye is on this call. And lastly, let me just quickly read David's intervention. So he says that while proliferation of trade unions should be discouraged from the essence of trade unionism, it is unjustifiable to bestow the right to unionize on employers who are by default the stronger party as he who has the employment, dictate the time of the relationship. Trade union, by its implication, is strictly meant for workers who are to use it as a medium to counterbalance the unequal power equilibrium in the employment relationship. Despite this, in Nigeria, the Trade Union Act requires a minimum of 50 workers to form a trade union, but 2 employers to form an employers union. Aside from the fact that the right to freedom of association is constitutionally guaranteed in Nigeria, a mere act of the National Assembly has restricted it against employees. This is draconian and employer-friendly and workers-unfriendly. Such a heated discussion we are having here. So let me put you on the spot, Jeff, and then we are going to hear from Adewale on this.
Yeah, I'm going to leave any questions about inter-union disputes and sibling rivalries to the union representatives on the call. I'll just say the ILO, as I mentioned in my introductory remarks, the ILO the Convention on Freedom of Association has said that workers have the right to form or join unions of their own choosing, right? So this is meant that usually legislation which puts limits on the number of unions per sector or per workplace, or the number of federations or confederations, are usually treated with suspicion because that limits the right of workers to form or join unions of their choosing. So cases where there are union monopolies are obviously run afoul of freedom of association. Yeah, I do fully understand on the other hand that having a multitude of unions can dilute or weaken trade union strength. But this, I think, from the point of view of the ILO, is that this is something for workers and unions to sort out themselves and not to have imposed through legislation, right? So that's, I'm going to say, the answer to that question. And then on emergency powers, I mean, it's always been a question as to whether, when an emergency power is invoked, whether there is actually truly an emergency, right? Because there are many circumstances where governments will impose an emergency power when there isn't truly an emergency, or they will impose an emergency power, but it will remain enforced long after there is any emergency that could justify the imposition of that power. So I think so yes, I mean, I think there have been in the past challenges to, limits or prohibitions on the right to freedom of association during emergencies, in particular, where the limitations were excessive, were not necessary in the light of an emergency, right? Or the emergency decree goes on for months or years, right? So there have been, I think, successful challenges in that case. So I think those are the 2 questions to me.
Thank you so much, Jeff. Adewale?
Hello?
Hello, yes, we can hear you.
Well, on the issue of first, we don't NECA doesn't support casualization. But there's no casualization. The law frowns at casualization, and as such, we also frown seriously at issue of casualization. The law allows outsourcing, and currently we know there are serious efforts, serious efforts and ongoing effort by the Ministry of Labor and also by the Employers Federation to ensure that all workers working for outsourcing companies, irrespective of the sectors that they belong to, that they currently they all have the right to organize and also to collectively bargain. So anybody practicing within the context of casualization is actually breaking the law, which definitely we do not support.
Thank you so much, Mr. Dewale, for responding to the issue of casualization. So just quickly, because I can see that we are now close to closing up, a comment from Stella. The right to strike should be mandatory. After all, the world survives only on the strength of labor. In Nigeria, it appears that both the executive and judiciary are in agreement to suppress labor rights, especially the right to strike. Nadi says, how can we assist in the expedition of the pace of tripartite labor law reform? In some context, the amendment of the Employment Act and the Industrial Relations Act takes ages, much to the frustration of progressive labor reforms aimed at the promotion of labor standards. And Maureen Kalume, hi everyone, hi. How effective is the right to strike in the long run? Is it an end or a means to an end? End being bolstering workers' rights. Thank you. That's quite mind-boggling. Robina says that in Uganda, a national tripartite charter was signed, which stipulates, among other things, 1 union per enterprise. So when a union is already organizing a given workplace, no other union is allowed to organize there. Most importantly, the aspect of removal of the membership threshold before recognition relaxed the tension among unions since. This used to cause a lot of rivalry based on the issue of the most representative and the employer's right to derecognize the union whose membership had fallen below the threshold. So, I mean, we've had like various interventions here, but also comments and questions. But because of time, I'm going to allow Jeff to make maybe last remarks, but also maybe to maybe answer or respond to what, because that would be a great ending in terms of what Maureen has asked, whether the right to strike in the long run is an end or a means to an end. And also invite Adewale to make his last remarks. I can see that Comrade Uchenna is here. We missed you. He had issues with the internet. So maybe also he can maybe make some few remarks on the issue of freedom of association as we close, and as I invite Pami to make the closing remarks. Thank you.
Yeah, thanks. I mean, I think the right to strike is a very important tool, but I mean, it's not done for the sake of just going on strike, right? The workers taking collective action is essential in usually constituting trade unions to begin with, but also in exercising collective power in the face of repression, whether that is unlawful dismissals, failure to bargain in good faith, or even against government policy, which affects workers. I mean, there's a broad recognition of the right to strike and the purposes of the right to strike. Usually, so long as it has the issue has some broad impact, not only on collective bargaining, but the interests, rights and interests of workers generally. I think the ILOs found that those are appropriate reasons for the workers to strike in order to promote and defend their rights and interests. So I hope that answers the question. And yeah, I'll leave it there and hand it over to our colleagues.
Thank you very much for those closing remarks. I'm going to invite Comrade Uchenna, who is the head of Industrial Relations and Liaison to National Assembly of the Nigeria Labour Congress, but also member of, he used to be a member of House of Representatives from the year 1999 to 2003. We missed your interventions, Comrade, but I think you can take 2 minutes to give us your thoughts on the issue of freedom of association as we close up.
Yeah, thank you very much. I followed some parts. At least I listened to the introduction to the end. Picked a bit from the comrade from NECA. Because of the time, I might just weigh in to say that if you remove the right to strike, you have already totally made nonsense of the freedom of association in practical terms. And I can give some few examples. Now in Nigeria, because Nigeria is the case study where some employers take very horrible approach by first starting.
Am I the one who's having issues with to hear Comrade, or okay, it's a problem.
Knowing that there is heavy on, they make people to sign that yes, like the case of what the 10% of this workforce, they give them 3 months. Hello? Hello?
Yes, yes, we are having problem hearing. Maybe you could turn off your video and see whether it's going to be better.
It will be better, okay.
Okay.
Is it better now?
Yes, you have 1 minute.
Okay. So I give an example of where the employers that I said that removing the issue of the right to strike is like doing away with the entire process of even the freedom of association. I give an example where some employers get the worker due to unemployment to sign in that is never going to belong to a union. I was also given the example of what MTN Nigeria does, where they employ people only on contract for 3 months, they renew that contract after 3 months. Some people have worked for 10 years in that process. All attempts to get the MTN Nigeria to discussions failed until there was an action, a strike action. And the Nigerian government has shown a penchant that they are never going to take any agreement. This is already signed agreement serious, unless there's a threat to strike. To tell you how terrible this is wrong, even the 2 weeks notice will not be adhered to until a date to the strike itself. The last experience of the protest was where there were direct threats from very top government officials and warning threat to life of leaders of the union if the protest goes on. So if you remove that, I can tell you in the Nigerian circumstance, you can as well write 1 million letters, sign 1,000 agreements, and nothing will ever happen to those agreements. So the right of strike for us here is just a must. Hello?
Thank you. Thank you so much. Yes, we've heard you. We've heard about your experiences, and I'm sorry that I have to cut you because of time. I don't know whether there is anything else you wanted to add on that, but we've heard you.
Yeah, well, like the colleague from the ILO have said, the only thing I have to add is that we have already tried to file the cases of infractions on the right to freedom of association. And only to point out that you can see that even when the ILO, after several years of struggle, confirmed that and directed the Nigerian government that the custom and immigrations, as well as the export processing zones, have the right to have unions. By the right of freedom of association, the unions should exist there. But the government have not complied, and the unions don't exist there. And it's good to remind us that the custom and immigration used to have a union.
I think we've lost
Until
you.
the IDP administration through a decree sit in the ILO, and it took over these years, the last 4 years, to get a judgment that now say, yes, they have the right to organize.
Thank you so much for sharing that experience in terms of the right for workers in the EPZ in terms of freedom of association. I hope that there'll be compliance, full compliance in terms of that. I'm going to call Mr. Adewale to make his very short closing remarks.
Well, thank you once again. I think it's been an enlightening session, quite educative also. You know, for us, the need for continuous education is one of the things we've always emphasized. You know, continuous education within the context of what we do as labor and industrial relations practitioners, and also the need for all parties, all social partners, to work within the context of their rights, to work within the context of their limitations, to respect the institutions of labor administration, and then to continuously explore all avenues of resolving issues, first with social dialogue, and then with alternative dispute resolution mechanisms, before we exploit the final option, which sometimes might be strike. But within the Nigerian context, we have the Trade Dispute Act that specifies the steps that should be taken in resolving all issues before we terminate at the end of strike, if we think it's necessary. But the reality is that by the time you exhaust all the steps within the Trade Disputes Act, there is hardly any way you wouldn't have resolved the issues before you get to that very difficult decision of going on strike. So thank you once again for having us. And as I said, it's been quite an incisive and educative session.
Thank you very much, Mr. Dewale, and for that brief closing remarks. I'm going to invite my sister Pami to make some concluding remarks, but also to talk maybe in some few sentences about the African Labour Law Society, where she's the president, but also her work at WIECO. So welcome, karibu, my sister.
Sorry, for a moment there I was failing to unmute. Good afternoon, everyone, colleagues and friends, comrades in the labor law community in Africa. My name is Pami Zai, and I'm from Zimbabwe. I'm the president of the African Labor Law Society, and currently I'm joining you from Accra, where I'm visiting for a week. And I really want to thank Ellen and I want to thank ILO for this really great and fruitful partnership. We've really been able to have many conversations, which is what the African Labour Law Society is all about. The society was formed in 2016. Currently, we have a membership of about 300 labor lawyers in Africa, in almost 30 African countries. And we really are trying to, facilitate conversations, facilitate networking, facilitate collaborations amongst labor lawyers that are working in Africa or have an interest in Africa. And this series, I think, is really informative and it's stimulating because we're bringing in partners from we're bringing in the social partners. And we are grateful for this time and we hope that we'll continue to have these conversations. I'm going to ask President Jamil to share more information about the African Labour Law Society Conference. It's happening in August and it's all about gathering around the fireplace and sharing and exchanging our experiences and stories about labor law in Africa, which is something that's very, very much needed. We need to fill that gap regionally and we need to take up space at on the global scene. Thank you very much for this opportunity and I hope you have a good weekend.
Jackie, are you?
I guess we lost Jackie.
Yeah.
Okay, so she's given us one song before she got disconnected. So I guess just to say good evening, everyone. We're going to be sharing information about the African Labour Law Society conference happening in August in South Africa. You could visit the African Labour Law Society website or their LinkedIn page. Ellen also has his social media channels on LinkedIn and Instagram. I guess we'll leave it at that because the evening is fast spent. But thank you very much all for joining. This International Labour Standards webinar series continues next month. I think next month we should be doing something on discrimination. So please follow us, African Labour Society and Airline, and also ILO for information on the next webinar. It will be just as interesting as this one. So bye everyone and keep safe. Okay, Jackie is back. She wants us to share the result of the poll, but unfortunately I can't see it again. It seems to have ended. But I guess with all the interventions.
So it's 94% on the first question.
Okay.
Do you think workers in the informal and digital economy has a right to organize? So 94%, and we have a no, which is 6%. And on the next question, do you think that the right to strike should be absolute right, which is 44% yes, and 56% no.
It's interesting.
Yeah, that's quite interesting. So that's those are the results of our poll. Thank you very much for participating. Asante sana for being here. We really appreciate you. Check our websites, ILO Network, ELAN, but also the African Labour Law Society. If you're interested to be part of the movement in labor law and all that, you're very much welcome. So kwaheri, good evening, good afternoon, wherever that you're joining.
From Nigeria.
Okay.
Bye.
Bye-bye.
Bye, Africa.
Bye.
Bye.